Thank you, Judge. I first want to say it's very apparent that you're putting a lot of time and thought into ensuring that Mr. Hillygus' rights are respected in this process, and I really appreciate that.
Judicial District Court in the state of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you. Please be seated. Okay, we're on the record in the case of State of Nevada versus Roger Hillygus. Court recognizes Mr. Stege representing the state and Mr. Hillygus self-represented. Mr. Hillygus, I see that you are, because you're in custody, and I think we talked last time you were here about having your hands free. If you promise to comply with court orders with respect to your being unshackled, the court will order the deputy to free your arms. You don't anticipate any issues with that, Mr. Hillygus, do you?
No.
Okay, the deputy, if you please release both of Mr. Hillygus' hands.
Judge, Mr. Hillygus is asking him to remove the waist restraints altogether, or do you want his hands out?
Well, can you move your hands freely? Yeah.
I can, but I've got this chain wrapped around my waist that makes it hard to stand up.
Well, let's see if we need to have you stand at any time when you're addressing the court, and then we'll make a decision. But right now, I think we're good.
Can I remain seated?
Say that again?
Can I remain seated?
Yeah, you can remain seated. Give me just a minute here. Right. This is the hearing that the court set to follow up on our recent hearing with respect to many issues. Importantly, though, Mr. Hillygus' access to the discovery, electronic data, filing, computers, paper copies, things like that. The court, after that hearing on or about June 16, filed an order regarding defendant Hillygus' electronic and discovery access while in custody. The court did that after a level of collaboration with the court's filing office, Washington County Sheriff's Office, court administration. Tried as best it could to fashion an approach that would account for Mr. Hillygus' in custody self-represented status, take into account the nature and severity of the charges against him, the upcoming trial date, recognition that we have rules that apply to people and they need to be applied, and we're not markedly or materially changing them for one person and then encouraging that to be the new normal for everyone. So the order went out, and there were two objections filed to that order. One was by the Washington County Public Defender's Office, who is graciously present here today through the new Washington County Public Defender, Mr. Grosnick, objecting to that portion of the order that sought the Washington County Public Defender to provide a laptop and other accessories, noting, and I'll hear from Ms. Grosnick in a moment if she'd like to address the court, but essentially noting that really not part of their job responsibility, also resource responsibility, things like that. The second objection was by the Washington County District Attorney's Office through Mr. Stege, specifically to that portion of the order that required paper copies of the discovery and filings that have occurred in the future, indicating that electronic essentially should be sufficient. That's just paraphrasing. The court met briefly this morning with the Washington County Sheriff's Office, court filing staff, court administration, again, to take another look at it. and was considering that, unlike in the United States District Court, where I understand for a self-represented litigant, it would be the United States Public Defender's Office, Federal Public Defender, to provide a laptop. The court may have gotten over its skis a little bit and directed the Washington County Public Defender to do something which they ordinarily wouldn't be doing. So the question is, who then gets the laptop to Mr. Hillygus, and what type of access will he have for reviewing, filing, and research? Then the question from the other question is from the state, is it simply a matter of resisting making paper copies, or is it something more than that? Let me start there first. Mr. Stege, what's the concern, please, and how would you propose the court to address the concerns that were raised at the last hearing and codified in the court order?
So, as I pointed out in my objection, rules favor electronic service. This is a district where e-filing is mandatory. The court can make findings for people who don't have internet access and allow them to file things the old-fashioned way, if you will. As to the discovery issue, now I certainly appreciate that the court is trying to make this situation work.
Well, I would say I'm trying to find a balance, right? A balance, taking into account that we have trial in 2 months, right? That Mr. Hillygus is charged with several serious crimes, that I want to make sure he has access to the discovery, to filings, to court orders, take into account legitimate security concerns raised by the Washington County Sheriff's Office, and move this case forward. So that's the background.
Right, and so the law has very little to say about the manner in which the prosecution turns over discovery, right, or the defense turns over discovery. It is largely run by the parties unless there is an issue which the law allows them to bring before the court. So the court's preference for paper, it doesn't make sense when a large part of this case involved digital media, right? If there's going to be things like body-worn cameras, recorded interviews, which are in digital format, it does not make sense to then have 5,000 pages of paper in addition to that. It's also...
Well, let me stop you there. You know, paper can be in a box or boxes,
right,
in Mr. Hillygus' cell, and he can wake up at 2 in the morning if he's thinking about his case or can't sleep. He can go through it. He can take a pen and make notes on it. Whereas digital access, you know, is more limited, more circumscribed.
Right, but I would say the law doesn't care. The law says...
But the court cares when we have a trial in 2 months.
Right.
And he's behind the curve because we had an issue on competency until fairly recently.
Well, I would say he's not behind the curve. I would reflect back on this, Your Honor. Up until the time where he fled the jurisdiction, you'll find in the court's file that we gave notice that discovery was available for pickup at our office. I think he did not. He never took advantage of it. But it's always helpful, I think, to come back to the law. And the law, the court almost never gets involved in having a preference for how discovery is turned over or managed for that matter. So the court's belief that paper is easier, in fact, is more burdensome, right? And the law, the Supreme Court law says you're not getting special privileges. Yes, the court can envision him wanting to get up in the middle of the night to have paper in his file, but that sounds to me exactly like a special privilege. When
he's in custody, right?
Yes.
If he were home and he woke up at 2 in the morning and he had access to his computer, he could review the discovery produced by the state, but he's not. He's restricted.
Again, I come back to he's not the first self-represented person in this district or anywhere to represent himself. You've had much higher profile, much more serious.
To represent himself 2 months before trial.
Right.
To represent himself 2 months before trial, where he's facing multiple serious felonies.
Right. And so
slow down his ability to properly defend himself because he has restricted access to information that he may need to properly prepare.
Okay, yeah, and the court is presuming that paper is easier for him and that there will be, put another way, the man has nothing to do, right? And so whether it's at 2 o'clock in the morning or during the regular course of the day, the format, I would say the law has almost nothing to say about. Now, if you want, I'll give you 5,000, but, so I would sort of urge caution there, right? That if the court were looking for a hook in terms of the manner in which discovery is handled, I think it might take a little bit of searching to find one. But should the court find one and order paper plus digital?
Well, I've already ordered. So
Okay.
right now you're asking the court to reconsider.
Yes, right. Well, and I'm also, I will say, a bit concerned that, no input from the prosecution office is used to handling thousands of discovery cases a year. Zero consultation from the sheriff's office on this subject in terms of ease, right? In terms of best practices in this situation. In any event, we'll turn over the paper, but we still have this issue of the digital media.
Well, we're going to get to that, right?
Okay.
We'll get to that too.
And on that subject, the public defender's objection is well taken. We're not a party to this case. This sort of idea of parties of convenience. I think the order contemplates, well, the PD's a party of convenience, make them do it in the same way. Well, paper is more convenient, let's do it in paper.
Actually,
let me
sorry to talk over you, but you just spurred a question in the court's mind. Who makes sure that Mr. Hillygus has proper clothing to wear to court on trial days if the Washington County Public Defender is not involved?
Well, they're not appointed. I presume it's the jail, right? I say overall, what the Constitution requires is that the defendant have reasonable access to prepare for trial, right? That does not mean special privileges. In fact, I don't even know that would go so far as to say, have anything to say about jail clothes. But again, here we are solving a problem for a self-represented litigant who does not get extra help to be a self-consideration. Should he have a motion for clothing, I'm sure the court can come up with a good resolution to it. So I would always come back to what does the law say about it? The law says the Constitution requires that the jail provide him reasonable access to prepare for trial.
Let me summarize what I understand your position is. Judge, there's a lot of digital media, digital discovery, videos, audio. We have to make sure there's a remedy here that allows Mr. Hillygus access to that. If you force us to print out every piece of paper, in this case, a discovery piece of paper, going forward and get it over to him, we'll do it, but we'll do it holding our nose. We don't think we should have to. We don't think it accomplishes anything, and we don't think that reasonable access requires that. I summarize your argument?
Yes, and I would say digital is easier than paper.
I understand your position. So, Mr. Hillygus, talking about at the last hearing, you said, Judge, I don't have this, I don't have that, I don't have any of this, and I would like paper copies. Have you thought about that, and what's your position on all that, please?
Thank you for allowing me to be seated to address the court, but I would like to address the court, and I'd like to have my right to be heard, and I'd like to have my right to defend myself. I come in peace, I will remain in honor. I call for a transcript of this hearing, and I'd like to be sworn in.
Well, I'm not swearing you right now because
I'd like what I say to be sworn testimony is to be true, and that's what's coming next. I do not consent to contract with your for-profit corporation. It has a Dun & Bradstreet number, and I object to this hearing as you lack jurisdiction. I'm appearing by special appearance, and I've challenged your jurisdiction, and it's not been proven through the record. And I'd like to cite some of the cases that I've cited.
well, let me stop you right there.
Bailey versus Sherrod.
Excuse me. I'm not here right now to discuss with you your philosophy on or your approach to or your belief in the court's jurisdiction. We're here to talk about access to discovery, access to computer, access to paper filings, making sure you have time to prepare, things like that. Now, I realize you have other things on the agenda, but right now, the court's not here to go over that.
I appreciate your denial of jurisdiction, but jurisdiction is everything. Without jurisdiction, you have no authority to make any decisions in this case.
We don't have to explain to the court what the law is.
I've
What I want to know,
cited case law from the United States Supreme Court, SCOTUS, that challenges your jurisdiction. I've cited 50 cases that challenge your jurisdiction, and you have not responded. So without jurisdiction, you have no ability to make any orders in this court. Your orders are null and void and unenforceable, and you're a trespasser on the law because you are moving forward in a case without jurisdiction.
So let's
I
do
want to
this.
talk about your order right here.
All right, hold on. Let's do this though, because the last several times I've seen you, you've indicated that you object to the court's jurisdiction. You believe the court lacks jurisdiction. You can have an ongoing objection. You do not need to recite it or repeat it every time. Your objection is preserved for the record.
I agree with you that my objection is preserved for the record. I just like to cite some of the case law that I've cited explaining why I believe that you lack jurisdiction.
Well, we've gone over that before. Now we're
No,
moving.
we have not. I have not cited Bailey versus Sherrata, State versus Huller, Huff versus Shepard, Mahoney versus Boise Title and Trust, Menlo versus U.S., Higgins versus Levine, Stenard versus Olson, Maine versus Tillabot, Struck versus Medical Examiners, Roseman versus Lambert, Lantana versus Hopper. A lot of those are Supreme Court of the United States, Supreme Court case law that challenges your jurisdiction. Once jurisdiction has been challenged, it must be proven through the record. And there is no proof through the record that you have jurisdiction, you lack jurisdiction. So therefore, your orders are null and void and unenforceable. You are a trespasser on the law. Your orders are nullities. You are an officer of the court, and you hold your office under good behavior. By proceeding, you're committing a fraud on the court. You can be impeached by the Nevada legislature for bad behavior. I'd like to submit a letter that was written and filed on the record as evidence into the record. This was filed
Mr. Hillygus,
May 10th.
Mr. Hillygus, here's how this hearing is going to go. I've shown you some leeway here, but we're at the end of the court's approach to that. What I wanted to focus you on is what this hearing was set for, is to make sure you have access to information and to research opportunities and to filing opportunities sufficient to defend yourself. You heard the court's concerns. You heard what Mr. Stege just said. Could you please respond to those, or I'm going to move back to Mr. Stege.
Okay, I will address the order that was filed on June 16th at 10:21.
Yes.
This does not cite one statute or rule. This does not cite one federal or SCOTUS case law. This does not cite one Nevada Supreme Court case law. This does not mention my rights once. My constitutional rights are being violated. This order is null and void and unenforceable because I have a right to access the courts. I have a right to speak. I have a right to redress my grievances and to be heard or to remain silent.
Okay, so what portions of the order would you like the court to revise? Do you still want copies, written copies of the documents?
That, as admitted by you, there was ex parte communication in the formation of this order. I have a right to due process under the law. The objection was not served on me by the state. I do not consent to contract with any corporation for a laptop. This order is null and void and unenforceable because it's violating my rights.
Mr. Hillygus, you're dangerously close to being held in contempt by the court for being disrespectful.
This order is
Mr.
null and
Hillygus,
void.
I'm only going to warn you one more time that I'm going to have you removed from the courtroom. So put that
This
down.
does not cite anything about my rights.
I
It talks a
understand
half a page about a pencil and a pen. It does not talk about the rights that I have. My rights are being denied by the jail. I am being held unlawfully.
Mr.
I'd like to
Hillygus,
be released immediately today.
Mr.
Because this
I
case
have
does not,
to refocus you on what we're here to talk about. We're here to talk about access to the filings, access to legal research, access to review discovery from the state.
I have not been provided one piece of evidence, one piece of discovery from the state.
And you heard this, Mr. Stege say that you were notified it was available at their office to come over and pick up before the competency issue began. Did you hear him say
There
that?
was no issue with competency, that's been resolved, so that was a fraud on the court as well.
Are you still requesting paper copies?
I like anything he has that's on digital to be transcribed. So if it's a body cam, they're speaking, people speaking, that can all be transcribed into paper
Well, the court doesn't.
so that I can use that for an appeal.
The court is not requiring that anybody to transcribe any.
That's my right. As a criminal defendant, I have a right to have all the transcribed records provided to me in paper form. That's a constitutional right. I would like everything transcribed so I can use it for an appeal. Because this case, it doesn't exist. You've lacked jurisdiction and I'll continue to challenge it. I do not consent to contract with a for-profit corporation acting and pretending to be government under the color of law.
All right, thank you. Lieutenant Ben, do you have I see you here on behalf of the Washington County Sheriff. Would you mind addressing the court about the status of any potential laptops that could be made available to Mr. Hillygus and how that would work, when he could get it, who would deliver it, what restrictions of use or access would be set forth. And I also see Michael Large, Deputy Washoe County District Attorney, who I think handles issues like this in the civil division. Mr. Large, if you want to address the court as well, I'd really benefit from your insights.
I'll let Mr. Ben speak to the computer and laptop.
Okay, Lieutenant?
Lieutenant Ben for the court, BENN on behalf of Washoe County Inmate Classification Unit. What was the question from the court?
Who would actually physically deliver the computer? Who has the laptops? How would what access would be allowed? What kind of search efforts, could be undertaken? How is legal research done? Is it on the tablet or would it be on the laptop? If eFlex filings were to be made, so how would that go? If I had the Washoe County Sheriff's Office deliver a laptop to Mr. Hillygus as opposed to the Washoe County Public Defender's Office? I know that's a lot to unpack, but.
That is, Your Honor. I'll start with the legal research. That's the easiest one. The inmates in jail are provided tablets. On that tablet, we provided the law library for them to access whenever they have a tablet. I believe accommodations were made in the order for Mr. Hillygus to have that tablet in his cell at reasonable hours, and he can conduct unlimited research on his own on that tablet.
Okay.
For the laptop for digital discovery, your original order asked the public defender to provide that. Our understanding at the time was that the public defender would use Washoe County IT. The sheriff's office, if or so ordered by the court, would work with Washoe County IT to provide a laptop. That laptop would be closed to the internet. It would have a media player that allowed digital videos to be played with audio, and it would have access only to eFlex. And the question of a scanner is still being debated as far as the acquisition of that scanner. That would be allowed Mr. Hillygus to file his findings through the eFlex system through that scanner. The computer would be limited to the multi-purpose room at the jail for safety and security, and Mr. Hillygus would be granted up to 2 hours a day unless the facility emergencies change that schedule.
Okay, what about if the court moves forward with his prior order to require the district attorney to reduce written discovery to copies and get a box or 2 or 3 up to the jail? Is there somebody there that the jail that could receive them, deliver them to Mr. Hillygus, and would he be allowed to keep them in his jail cell?
You would be allowed to keep them in his jail cell, Your Honor.
So he could
provided
access
that they
them.
weren't misused. I would ask that the court place language in any order that limited him to using legal paperwork in the storage area for that purpose of legal research for his case.
As opposed to pushing it out to other people, as opposed to mailing it to people, as opposed to doing something other than to assist him in defending himself?
Correct, sir.
What's the issue with the scanner? Who has one and who could set it up for him and make sure that he would be available?
Can I please refer to
Sure,
Washington
Mr.
County?
Larch, yeah.
The sheriff's, Mr.
Michael Large on behalf of the Washington County Sheriff's Office. The Sheriff's Office doesn't have a scanner up there, and in terms of IT, Washington County IT, we're not certain that there is a scanner available. We were hoping to have the IT representative here.
Well, what happens if Mr. Hillygus wants to file something?
He can, as Mr. Stege said, he can file it the old-fashioned way, pursuant to if the court were to craft an order of that. Essentially, but what we're doing is we're essentially making the sheriff's office, in terms of who's in charge of this custody, but is not a party to this action, putting obligations on them in terms of accessing the courts that are outside the purview of the constitutional requirements. So
File it the old-fashioned way, as in paper form?
as in paper.
So where does he get a printer to print out what he wants to prepare and file?
I'm not sure that the sheriff's office has a printer either in that respect.
So, Mr. Stege, it looks like you want to be heard.
Well, you have defendants, self-represented, who file their motions in written form, handwritten form.
Yes.
No.
They'll use typically, pro se, will write out what they want to say.
On legal paper?
Either on legal paper or on plain paper.
And somebody types it up for them?
No,
And they file it that way?
they file it that way. As you've seen, as your Honor has seen in numerous inmate litigation cases.
Thank you, Your Honor. If I may, I have some concern too about any order that would allow Mr. Hillygus to request us print documents he's preparing, as it puts us right in the middle of handling his legal paperwork, which is confidential, and then ensuring it is legal before we provide it
All right,
back.
so let's suppose he writes something out on legal pad or plain paper that he wants to file. How does he get it filed if he doesn't have a scanner?
He can mail it in, Your Honor.
Well, that's a little unwieldy with trial 2 months away. What's the next best approach?
We can, if your Honor was going to do an order and obligate the sheriff's office to buy a scanner for the inmate's use up there, then we could allow access during that 2-hour period. But at that point, the sheriff's office is having to flip the dime for this, and it's not.
Well, I don't want to start a precedent here and invite this type of request on a regular basis. I just want to find the right balance here. Another option is that somebody who's coming into the courthouse takes it over and and delivers it to the filing office by hand.
And then the sheriff's office is acting as a courier, and we have the same issues in regard to.
It could take a week, it could take 5 days if it's mailed from the jail for it to get to the filing office here. That's really time we don't have.
Is that the case? Like,
It's my understanding, Your Honor, that mail that is, it would be mailed the same day, put in the mailbox the same day that Mr. Hillygus gave to us. Beyond that point, it's out of our control. It would go to, as I understand it, Carson City before it's redirected up to Reno. And that would cause the delay of a few days. It wouldn't be overnight submission. But I have to admit, I'm not an expert on the mailing, the post office procedures for mail from the jail.
So the options are direct the sheriff to obtain a scanner, which then takes time, get it, plug it in, make sure it's talking to the system correctly, and then you're the liaison between what Mr. Hillygus wants to file, scanning it, and making sure it gets sent. That's not the court's first choice. The next is to have him handwrite things he wants filed and have it go in an envelope and have it mailed to the court. That's how it usually goes, but we're a little crunched for time. The third option is we find a way to have somebody who's coming down from the courthouse bring it down and drop it off in the filing office on court days that you're going to be down here. So it sort of gets here 24 hours or so or less. Those are the three options I'm seeing.
Your Honor, the other option that I can see is potentially appointing standby counsel and having them deliver it to the courthouse.
The idea has occurred to me. Mr. Stege, something else you'd like to add?
Yes, Lieutenant, any security concerns as between a paper copy versus the proposal for a computer or electronic discovery?
No, there's not. We've had defendants in the past that have had access to laptops in the MP room. It's been coordinated and documented. He wouldn't have the laptop in his cell, it would just be in the MP room. For up to 2 hours a day would be our suggestion or our request. The paper in his cell, it doesn't cause a significant threat to safety, security,
As long as it stays there and is used for preparation for trial purposes, right?
That is correct.
With an order, you would request an order for non-dissemination order. Is that what you're talking about?
Yes, sir.
The
The equipment provided by the court, both paper and digital, will be used for the express purpose of Mr. Hillygus in preparation for his defense and not for filing papers for other inmates or for frivolous use, sharing it with other inmates. It's for him to prepare for court.
And specific, would you limit that order or add to that filings for this case as opposed to other cases, to either?
Yes, sir. We do have a contract with Northern Nevada Legal, formerly Washoe Legal Services, that is legal access for all inmates for any civil issue at the jail that they feel they need to file for that's not related to their criminal defense. So the scanner and the laptop would be used for specifically this case in preparation for his defense, not for filing additional lawsuits, which there is legal aid available, non-related.
Now, Lieutenant Ben, I wonder if you can talk about either yourself or sort of the institutional practice dealing with other self-represented litigants, or what practices have been employed to address some of these issues. Like the Mac case comes to mind, or some other high-profile cases.
With considerations we consider are limited to what phone access he has. We request that it follows prior practice of that the defendant would have to use the facility phones to make his calls and not request an outside line independent from what goes through our communication system. So in other words, not using a deputy's phone or a unit phone, but use the phones that he has access to on tier time.
What about filing of motions and other, have inmates been able to, in the past, successfully file motions by mail in the manner that has been described? Handwrite it out, send it to the court, and have it filed?
Yes, sir.
And does that also apply to sort of the non-self-represented, like things like kites that are sent to the court? How does that system work?
The smart communication system uses a tablet, which directly sends a request to the court, but I believe that those aren't confidential in nature. Which would be the problem with the tablets and using a tablet for filing.
Well, that's assuming a filing needs to be confidential, right? But if an inmate sends a kite to the jail, that gets sent electronically.
That is correct.
And would there be a barrier to typing in that sort of system, to typing as the kite to the court a motion? Does that make sense? Put another way, is there any like limit on the number of characters that you can put in that kite to the court?
Yes, sir. There is a limit. I believe it's 500 characters, but I have to research that. There's also, I would express concern with the formatting of the kite coming in. As far as paragraph structure, the numbers on the side of the legal paper, it's not set up for that, would be my concern. But I'm not an expert on the smart communications in their way they send those messages.
And in terms of, has there been any discussions with the filing office of the court on how to handle this particular issue, filing of motions?
There has been, sir, but I would ask to defer, and the court defer to
Filing office people.
filing office people. Be more articulate than I will be in the matter.
Now, let me ask, if mail, say a motion is sent to or a pleading sent to the jail to be sent to an inmate, how long does that process work? Example, if I filed a motion and mailed a copy to 911 Park, care of the defendant, how would that process work?
Once we receive the legal mail at the sheriff's office, it's sorted by unit type, and within 24 hours, it's brought down to the unit, is handed to the respective inmate, still sealed, and it's opened in front of the inmate and inspected for contraband and to make sure that's legal content, and then it's given over to the inmate.
Are you aware of the defendant's sort of administrative compliance in custody to date? Does that make sense?
I couldn't quite hear that question.
His sort of administrative compliance or administrative issues with the defendant.
I'm aware from a higher level, sir, I would defer to my inmate classification specialist, Sergeant, which I have in the courtroom today, more familiar with the day-to-day operations at the jail as I'm working out of.
Well, what I'd like to know from any of them that can address the court is what we have been discussing in their mind a workable approach here to balance protocol, safety, and in recognition of the upcoming trial date and reasonable access? Or are you seeing or hearing something and you're saying, no, that won't work, or here's how we should build this a little bit better? Who can address the court? Would you please take your name for the record?
Sergeant Samuel Vanderwall, VANDRWLL.
All right, thank you, Sergeant. Any input on anything you've heard kicked around here this morning?
Everything that I have heard that has been proposed seems to be things that could be implemented at the jail. I don't see any major issues with what has been proposed so far.
So we could make it work, even if the court orders a scanner to be purchased and used, that we could make that work?
Yes, with the forethought that any technology could have problems, and if a scanner broke or a laptop broke, that we would have to call IT. Yes.
Right. Okay, appreciate your input. Thank you. And then Ms. Grozek, if you wouldn't mind, if you could just stand up for a minute, to answer this question. I mean, one option is that there's standby counsel, and then there's appointed counsel for a limited purpose. And sometimes, and the court takes responsibility for its involvement in doing so, but occasionally those roles are a bit conflated or there's overlap. So standby counsel is somebody the court would appoint to be available to Mr. Hillygus during the proceedings if he has questions, concerns, is unclear, unsure, wants advice or input. Appointed counsel for a limited purpose, as has been the case through the competency proceedings, was a specific task, a specific area that the court was asking the Washington County Public Defender to become involved in and to counsel and assist and advocate. Here, one option would be, instead of this bit of possibly workable, but it seems slightly unwieldy approach, would be for the court to appoint the Washington County Public Defender's Office for a limited purpose of assisting with the flow of information from the district attorney's office to Mr. Hillygus, and from Mr. Hillygus to the district attorney, or from the court to Mr. Hillygus, or from Mr. Hillygus to the court. As in, whatever he wants filed, the Washington County Public Defender files it. Whatever is served, we make sure he gets a copy. With respect to the discovery, the electronic discovery, make sure there's a flash drive, and you collaborate with the Washington County IT staff and the Washington County Sheriff to make sure that it's working and Mr. Hillygus can review it. Things like that. Thoughts on whether that might be an approach? A polite no thank you, or yes, great idea, somewhere in between. What do you think?
Thank you, Judge. I first want to say it's very apparent that you're putting a lot of time and thought into ensuring that Mr. Hillygus' rights are respected in this process, and I really appreciate that. I do object to being appointed in any kind of role at all other than full counsel for Mr. Hillygus. I think that, well, one thing I would bring up, all of these problems or roadblocks or challenges that the court is looking at to ensure that Mr. Hillygus has access to the court, has access to the ability to put on his defense and be prepared for trial. All of those things, inserting the public defender's office is just another link in the chain between Mr. Hillygus and the court. And I think that that's the main problem. Having our support staff, which we're already understaffed at this time with support staff, having them have to dedicate potentially hours a week to filing everything for Mr. Hillygus, I think is very problematic for our office. It's not something that we're in a position to do. What we do is we represent individuals. We have attorneys who review discovery, analyze legal claims, determine what investigation needs to be done, file appropriate motions. We're limited by the rules of ethics, by statute, to those things. And all of those things serve an important purpose in our process and our representation. My concern is opening up our office to ethical issues potentially with what gets filed, whose name it gets filed under, and then also the volume that could be taking away from legal filings that we need to file on behalf of clients, dedicating staff resources, other resources to doing these things on behalf of a pro per. And so I would respectfully object to that. The court has, I'm not sure if this department has recently, but I know that the Second Judicial District Court has had pro litigants in criminal cases before. I was a law clerk in Department 1 back in, I think, 2013 when we had a murder case with a pro per defendant. It can be done. And I would respectfully request the court and put a formal objection on the record to appointing us in any limited capacity.
Okay, I understand your position. Thank you.
Thank you.
Mr. Hillygus, anything you'd like to add with respect to the issues that have just been discussed, either from Deputy District Attorney Large, Deputy District Attorney Stege, Lieutenant Ben, or from Washington County Public Defender Breslow on those issues?
Moving forward, but what they're attempting to do to me is a violation of my Fourth Amendment right. They're monitoring everything I do. That's a violation of the Supreme Court case, Lewis versus Casey. It's not confidential. I do not have access to research organizations or groups or unions. I'm working with the ACLU. The DOJ is involved in this case. They're investigating the Washoe County Sheriff's Office. So by them trying to give me access and they're monitoring everything I'm doing, how can I possibly put on a defense when they're going to be monitoring everything? It's not confidential. So I don't consent to contract with the Washoe County Sheriff's Office or the Public Defender's Office. And I appreciate Mr. Grossnick's not wanting to be involved.
Well, if we give you a laptop, will you use it? If we give you a tablet to do research, will you use it?
I'm being held unlawfully against my will. This is not a criminal case. There is no probable cause. There has been no probable cause certificate. There has been no probable cause writ. There has been no probable cause hearing. There is no judge that has issued any probable cause in this case. So without probable cause, without jurisdiction, this case is null and void and unenforceable. Your orders are null and void and unenforceable. I demand to be released immediately as I am being held unlawfully against my will. And I'd like to make a record.
Mr. Hillygus, that's enough. I've heard enough. If you have anything else to say with respect to the discovery served on you, your ability to access the courts, the ability to prepare your defense, the ability to submit things for filing from the court, now's your time to address it. If it's your continued concern with the manner in which this case is being pursued, I don't want to hear it right now.
Staying locked down 23 hours a day is a violation of my rights. The internet goes off multiple times throughout the day. 2 hours is not enough time to do any kind of research. The tablet is fast case and there is no clerk or librarian. There is no law library. That's not a law library. Fast case is not a law library. So my rights are being violated under Lewis versus Casey by keeping me detained and not providing me with proper law library, not providing me with a proper research librarian or a clerk or anybody that understands the law to do research is a violation of my rights. And I do not consent to contract with the Washoe County Sheriff's Office for a tablet, which they're providing, but I cannot copy and paste on the tablet. And they want to monitor everything that I'm doing, so I cannot do proper confidential research. So I do not consent to that.
Okay, I understand your position. Give me just a moment here. All right, I'm going to amend the prior order of the court that came out a week or so ago in the following ways. The court finds merit to the argument made by the Washington County Public Defender that it ought not be its responsibility to provide a laptop, maybe accessories, access. So the court walks that piece back. Instead, the court orders that the Washington County Sheriff Office, in collaboration with Washington County's IT department, get a laptop promptly to Mr. Hillygus and allow him reasonable access so he can review electronic discovery, evidence, etc. What type? Well, without limitation, body worn cam, audio, files, not access to the internet, not access to things unrelated to this case, merely to review evidence, discovery, information that has been produced in this case. Now, I say promptly. What do I expect that to mean? I mean this week sometime. The court will be extremely concerned if it goes past this week because, as we're all aware, next week is a holiday week. So this being Tuesday morning, it should be done no later than this time on Friday, absent reasons out of people's control. With respect to a scanner, I'm not ordering that at this time. I'm not ordering that at this time. Nor am I ordering that the sheriff on a daily basis deliver things to the filing office that Mr. Hillygus might want to file. At this point, we'll continue with mail service. However, if that turns out to be unwieldy, causing unnecessary delay or unreasonable delay, the court will review this again and find a much quicker way to do it. With respect to eFlex, the court wants to make sure that Mr. Hillygus has the ability to review the eFlex, the information that's on eFlex in this case, consistent with anybody else who's in custody and self-represented. With respect to the paper files, while the court understands and appreciates the district attorney's concern that it ought not to have to do that, particularly in the age of computerized or digital court filings, the court finds this is a bit of a unique circumstance, and for this case only, the court will confirm its prior order in directing the district attorney's office to produce copies of the discovery and filings as previously ordered in paper form promptly to the jail to give to Mr. Hillygus. The court emphasizes, however, that it adds to its order that Mr. Hillygus is to use this information for purposes of this criminal justice case only. It's not to be disseminated to other parties. Not to be used by other people or given access to other people. It's for his use only in terms of this case. The court's envisioning 2 or 3 small boxes of which 5,000 plus or minus pieces of paper can get in. But the next time I have a hearing on this case, I do not want to hear that Mr. Hillygus has not had access to paper copies of the discovery or related matters in this case. The court is directing the state, again, unless it's for reasons outside of its control, to produce these records to the sheriff's office no later than Friday of this week at this time. Mr. Hillygus, when you want to file something, you can handwrite it on either a legal pad or plain paper, and we'll take it that way. It doesn't have to be on carded, numbered, legal paper. That's not your circumstance right now. I've indicated you have an ongoing objection to the jurisdiction of this court. I know you like to emphasize the reasons. You want to give the court case authority that you believe justifies your view. I get that, but when we're here for a particular purpose, your prior objections will be noted for the record and carry over to these further proceedings. Lieutenant Van, did the court overlook anything, or do you need any further clarity on any points that have been addressed? And then I'll ask Mr. Large the same question.
The Sheriff's Office would hope, Your Honor, that you include the time parameters for use of the laptop. And to clarify, you said no internet, but then eFlex review. So I asked the order to be specific that the internet access is limited to eFlex system.
It is limited to eFlex review. In terms of access, I think you said generally 2 hours a day, but you've heard the concern by Mr. Hillygus that there are times when he doesn't have the full 2 hours because something might be unavailable. The internet might be down, eFlex access might be down. How would you propose to handle that?
That's beyond my control, Your Honor, if eFlex is down. The time he uses the laptop will be documented, and we would be willing to produce those documents if requested by the court to show the actual time that Mr. Hillygus had access to that computer.
Well, right now, how is the court, how is the sheriff handling that in other similar circumstances, if there are any? Is it 2 hours?
There is no one else in the custody that has access to a laptop, Your Honor. This would be a unique situation. Each pro per that we have at the jail is handled specifically with a court order. This one, because the amount of discovery and the digital access, it's not a problem to put him in the multi-purpose room to give him privacy with a flash drive with the digital discovery on it for 2 hours a day at the most. That's what we'd ask for, but we will abide by Your Honor.
All right, Mr. Large, any thoughts on that issue?
The only point of clarification was just brought up, which is that in terms of delivering the laptop to him, it needs to be housed for security purposes, it needs to be housed in the multi-purpose room.
Yes?
And with only Mr. Hillygus having access pursuant to this court order.
Understood and ordered. So 2 hours it is, unless Mr. Hillygus later brings to the court's attention that's unreasonably handicapping him from being able to prepare a defense in this case. Mr. Stege, any other thoughts?
Is it accurate, Lieutenant or Sergeant, being locked down 23 hours a day and being limited as claimed to his access to the legal research aspect of the case? Sergeant.
I can speak to that.
Go ahead. And tell us again your name, just because, so we can make sure the record's clear.
Samuel Vanderwall.
Yes, sir. Go ahead.
Since his time in custody, the inmate management unit has been tracking the time he's been out of his cell. That averages per week between 16 to 22 hours a week outside of his cell. That does not include the times he's allowed to have a tablet in his cell for other legal research. That's specifically just time out of his cell.
Okay, so 2 to 3 hours a day.
Yes, Your Honor.
Fair? All right, thank you.
And how many hours a day can you do legal research?
He is allowed to have a tablet when he is in his cell. Those tablets do need to be recharged, so it can't be in there 24 hours a day. Typically, the tablets are not left in there at night, but during daytime hours, the tablets can be acquired and they have to be swapped out as they lose their battery power. And there is approximately 112 inmates in the unit. There is less tablets, so if there was 50 or 60 tablets, those need to be distributed to different inmates throughout the day so they can be evenly shared.
And are there 50 or 60?
There's approximately.
He can testify to the amount.
Go ahead and tell us your name, please.
Deputy Herman.
What were you going to say, please?
Yeah, there's approximately 36 tablets in each housing unit. We are acquiring more, but I do not believe they'd be here in time for this case to resolve.
Okay. Well, you understand the court's concern. I don't want there to be an issue that he wants to do legal research and, it's not charged, or, let's be attentive to those types of requests. I'm not asking you to change your policy for one person or one case, but let's just have our radar up to make sure there's no issues that are within our control that could be addressed. Mr. Stege, what else?
Only Lieutenant Ben, as respect to the paper files, are you requesting a limitation on where that goes? If the court is ordering the paper file, do you have any request as to limitations of where that might physically be?
We request that the paper files be kept in a tub that's provided for him in his cell, and should he require more than one tub, then he'll be provided that. It'll be explained to him exactly where he needs to. There'll be no tricks. He'll have a tub for his own private items, and then a tub specifically for his legal property. And Your Honor, if I may, with the tablets, can we place in the order, the hours between 11 p.m. and 7 a.m. tablets are not available. The system is designed for safety and security to shut those tablets off in the middle of the night, and to redo that would create a huge concern throughout the facility. I don't think we even have the ability to do just one tablet unlocked all night.
Okay, I hear you. Let me just ponder that for a moment. Mr. Stege, anything else?
Only, I would join the non-dissemination request. I would ask the court to reflect on my two motions for gag order, which are pending. For that dissemination, we don't want pretrial publicity with the discovery being pushed out. So I would join that.
Well, I thought I made that clear. The purpose of this order is to allow Mr. Hillygus reasonable access to the courts, to his files, to the state discovery, to any potential Brady material, so he can properly defend himself in this case. It's not designed for another motive, no matter how noble one might think it is. Mr. Hillygus, any particular reason you can think of that the court should not go along with Lieutenant Ben's request that tablets not be used between 11 p.m. and 7 in the morning? Are you the kind of guy that works all night and sleeps during the day? Is it you heard my analogy or my example before, if somebody wakes up at 2 in the morning and they want to get looking at their case, is that you? Or because right now you've just heard the sheriff say that would cause a problem for them. What do you think?
I do want to go over the amount of time that the internet is on and off. I think that's important. As far as sleep goes, it's sleep deprivation there. They keep you up till midnight. They wake you up at 3:30, 4 o'clock in the morning for breakfast. The internet doesn't come on until 8 o'clock in the morning. It goes off at 11:30. Doesn't come back on until 1. Goes off at 5. Does not come on again until 8 p.m. It goes off at 11. So they're constantly walking around shining flashlights in the cells all night long. So it's sleep deprivation. The internet sometimes doesn't work. It's off completely, but it's off during those times for sure. So 2 hours is not enough, and I will object now that 2 hours, restricting me to 2 hours when, as Mr. Stege says, I've got nothing else to do.
Okay, you've convinced me.
I need at least 8 hours a day.
I'm not going to do that, but I'll say 3 hours here, which is more than I think they're used to allowing in these types of circumstances, but the order will be 3 hours. And if you find that that's improperly, unduly restricting your ability to prepare your defense, let the court know, and I'll take another look at it. But right now it's 3 hours, right?
And it's my understanding that I'm not allowed to mail anything out of the facility. So
You can mail things to the court and with a copy to the prosecution.
And I haven't received the.
You're going to get their written discovery, written disclosures no later than this time on Friday, unless there are reasons outside the district attorney's control that prevent them from doing that. But they've already heard me say, I don't expect there to be any problem because we're getting into a holiday weekend and I want you to have this information by Friday so you can look at it over the weekend and into next week. Okay? All right.
I would like to make, I do need to make a record regarding some criminal acts that are occurring in this case.
Well, we're not.
Now, this is important, Your Honor. This is criminal acts by prosecution, by the Reno Police Department against my rights and against me and my family. This is important.
But so hearings are.
Fourth Amendment violations, Your Honor.
You can.
These are Fourth Amendment violations. These are illegal searches and seizures by the LA County Sheriff's Department, by DPS, by the Reno Police. These are crimes that are being committed against me and my family in this case. It needs to be heard.
But Mr. Hillygus, here's the deal. We're on a hearing right now to make sure that you have electronic and paper access to documents and researchability. If you believe that your constitutional rights are being violated, if you believe that something is going on in this case that ought not be, if you believe that
these aren't beliefs, Your Honor, these are facts.
Well, then you need to reduce it to writing, give the state a chance to think about what your concerns are, respond, and then the court will set a hearing or make a decision.
They have it all because it's been provided through the tablet, and they're monitoring everything I do on the tablet. So they know that the crimes that they're committing, they have access to that.
Okay, I understand your position, but right now I'm going to conclude this hearing. I want to
And
thank
they're
everyone.
continuing to go forward, knowing that they're doing criminal acts. If I was to do that, I would be strung up.
All right,
It gets just
That-
swept
Mr.
under
Hillygus.
the rug.
Mr. Hillygus, I understand your position. Here's what we're going to do. We're going to end this hearing. I'm going to set another hearing in the very near future, right after the holiday, to make sure that this is going the way we're hoping, and also to set a hearing on pending motions and go over a few of the things we need to handle. But at the next hearing, I'll also have Mr. Hanty, who I see here as an observer today, and his counsel, so we can make sure this case is tracking toward our current August trial date.
You've also been placed on notice through the common law, through a contract, and you've been given 3 notices and opportunities to cure, and you have failed to do that. So now a notice of default judgment and a judgment will be issued. So you've been served, you've been noticed, you've been given 3 opportunities to cure a contract that you entered into through your silence, and these have all been properly served and noticed upon you. So you have a conflict of interest to continue to sit in this case, because now you're in violation of a contract. It's a conflict of interest for you to proceed. So I ask you to recuse yourself from this case because you have been placed on notice. Thank you.
All right, thank you. That will conclude this hearing. We'll be in recess, everyone.
All rise.